Okay, well, welcome everyone for a random midweek stream. I know that I don't do this very often, but the Murdaugh trial, the Murdaugh trial. What the heck is going on? Every time this case takes a turn, I think it's going to go somewhere, and it goes somewhere different, and just too much to really take in. So, what did we have today? We had a bunch of stuff today that happened that some I expected, some I didn't expect. So let's see here. Let me think. Get my thoughts in order because here's the thing. I need to avoid a Friday Night Frenzy stream that did what it did last weekend, which was a 5 hour and 42-minute stream that kind of just covered on a single topic because we are recapping Murdaugh. So we're going to try and do some of this broken up over the week so that we're not doing the same thing. So Murdaugh, yesterday, the significant thing that I found out of yesterday was the medical examiner. Medical examiner took the stand, and she was the last witness on the stand and finished her direct examination at the end of the day. And I was left basically with two questions. Well, a couple of questions. One, the location of the shots. Two, the timing of the shots. And then three, the location of the shooter at the time. So let me see if I can go ahead and pull up some of this stuff. The location of the shots are kind of interesting because if I look at the dun dun dun, we can do these things because we know what we're doing. If I look basically at the layout of the scene that existed on that particular day, and if I pull the case's motion or the defense motion that was regarding some of the motion limine stuff, then I fast forward in the motion, and then I'll share it with you guys once I get to the place I'm talking about. Here is what we've got. All right, here's what we have. Now, this is from the defense motion that was a motion in limine regarding some of the testimony, rather the motion for sanctions about not turning over some of the information. This is compiled based off the state's evidence, and here's what I wanted you guys to see. So you have Paul, who's located right about here. This is where he is found. Some of the video pictures that we'll see here come from out there, looking back in towards the storage room. Paul is found with two shots, one to the upper shoulder area, arm area, and then the other one to the shoulder that went into the head. There is no way of getting around this stuff without giving you guys a little bit of a trigger warning because there's a lot of stuff that's talking about trajectories of bullets, etc. So Paul is shot here with a first shot that the ME is testifying to coming from the shotgun that hits him in the upper arm. And he is said by the ME to still be standing at that point in time. The shot has an upward trajectory, which is curious to me because I've seen some of the photos that show Paul and Alex standing next to each other, and Alex is substantially taller than Paul. Paul, I think, was 5'8". Alex, I think, is well over 6 feet. So the upward trajectory of the shots kind of threw me. But then it was this. It was the testimony that basically said that Maggie's gunshot wounds had stippling. Stippling occurs 3 feet, approximately 3 feet from the end of the weapon. And that basically is just marks that are found based on the discharge of the firearm that kind of causes an abrasion that you can see that is called stippling. So the ME is testifying basically that the first two shots Maggie takes are within about a 3-foot distance of where the end of the rifle is. Raised some questions for me. I was trying to figure out how that would have occurred based on the state's narrative. Because you have a shotgun that is shooting Paul, 2 shots. Second shot was essentially point blank range that discharged and evacuated his brain from his skull. The second shot would have been in such close proximity to have accomplished that. This was a lot of the sparring that was going back and forth between Mr. Harpootlian this morning and the medical examiner about how far away that distance was. But the second part of that, I think they didn't focus on enough. I think it was kind of a door that the defense left open. Rather, they didn't really circle back on that one. It's that if Maggie has stippling on her, that means the end of that rifle, the 300 blackout, was located within 3 feet of Maggie when it was shot, which means that the shooter, if it was one, had to have changed firearms, switched over to the 300 blackout, and then started shooting Maggie. And then here, these little number delineations are the different evidence of the expended 300 blackout shots. Boom, boom, boom. And then Maggie is found here laying this direction towards Paul. So Maggie's either running away or towards, running in some direction, but at some point, the shotgun in the scenario of one shooter was dropped and the 300 blackout was picked up. I want to preface this. I've shot a number of firearms and a number of rifles and shotguns. Real life is not John Wick. Real life is not John Wick. You don't have shooters that act the way that you see in the movies. The idea that a weapon is changed and the new weapon is shouldered and used in that short of a time is a big concern for me. It's a question for me. And that brings me to my larger point here. I went out and made some comments. Well, I've made several comments throughout the trial that the defense, I think, has, well, scroll back. This is what happens at the end of the day when you're working and trying to manage the trial stuff on the side. Let me see if I can compile how I want to say this the best way. Okay. Alex Murdaugh, not a good dude. Bad dude, terrible dude, horrible dude. Might have had all kinds of different motivations to do all kinds of different things. I'm not saying at all that he wasn't involved or knew or something to this effect. What I'm focusing on is the evidence that's being introduced at trial, because that's the evidence that goes back to the jury. And the way that this case was charged, the way the charging instruments laid the case out, was that Alex Murdaugh shot and fired both of these weapons and was the one that was in charge of, not in charge of, actually pulled the trigger on both of these murders. People have been going on about and saying, how does the two-shooter theory help you? How does it help you? One, I took issue with that. I'm not asking for anyone to help me or any position one way or the other. What I'm saying is that this is where the evidence is pointing. This is where the actual documents and the evidence, the forensics, are pointing to the possibility of a second shooter based on the timing. It's the timing. And the second shooter thing, if Alex Murdaugh hired a second person to help him carry this out, if he hired two people to carry this out, he is not guilty of the offense with which he has been charged. I want to be very clear on that. If Alex Murdaugh was down by the kennels, and let's say that he pulled the trigger on one of these deaths, he is guilty for that death. The state did not charge this as a conspiracy. The state charged this saying that he pulled the trigger on both killings. As a technical and purely legal matter, the state must prove beyond any reasonable doubt that he did just that he was the one that pulled the trigger on both Paul and Maggie. And the idea of having questions, you're going to have questions throughout a trial. You are absolutely going to have questions throughout a trial. At the end of the state's case in chief, that is where you are supposed to be the most assured of guilt. That is where there should no longer be any reasonable doubt in your mind that it was carried out in the manner that was relayed to you in the opening statement by the state. When the state gives their opening statement, they're basically giving you a promise. They're saying, we're going to promise you the evidence is going to prove to you this. And then they start laying out their evidence. The problem that I'm starting to have with the state, or that I've been having with the state, is that the state has been proving all kinds of stuff. But I don't know that they've really focused enough on proving this. I made comments last Friday that they came close to proving some of this stuff with Blanca. Blanca was the house boss, the house manager, the house total awesome badass who basically testified having observed and seen Alex wearing clothes that were different, meaning he changed before police arrived on scene. But that still doesn't get me to the shooting, how the shooting takes place. How does someone change? First of all, the question of how does the shotgun get positioned so where the shots are coming in an upward trajectory when Alex is significantly taller than Paul? That's one question. How does the shotgun get dropped and the 300 blackout is in such proximity that can be picked up, shouldered, and fired at Maggie. Again, I think the first shots to Maggie were upward trajectory. How does that get fired by the same person who dropped the shotgun? The reason I ask this, or the reason I make this comment, is that it's questions. Every question that you're left with at the close of the prosecution's case, when you are charged as a juror, you are assigned the role and you take the oath that you have to only view the evidence presented to you. And for every question that has not been resolved beyond a reasonable doubt, you must find that that question cuts in favor of the defense. I still have questions here, and it has primarily to do with the forensics on the shotgun, the ballistics rather. And the other questions I have to do with the timing. That's the questions. And if he shot from the hip, as so many people are saying that, I need someone to tell that to me. I need that to be argued in a way that make sense based on where he is when Paul takes that Snapchat video from inside the kennels. Get me there. Make the argument. Lay it out to me where that's feasible. Because throughout all of the medical examiner's testimony, we got a lot of information about how the shots went in, but we didn't get a lot of information about how a shooter could be positioned. I thought that was kind of interesting. We also didn't get time of death, which drove me crazy, because the time of death thing is something I thought the state would definitely want to introduce. But then I thought more about it and said, well, the state is not going to want to do that because a lot of people don't know about time of death. Time of death is not something like you see on TV shows or in movies where they can say the time of death occurred at this particular time based on the blood loss and the cooling of the body temperature. No, they can give you an approximation. They can give you a window. So if they give you a time estimate or an approximation, if the approximation given by the medical examiner goes beyond 9:06 as far as estimated or approximated time of death, then that creates a little bit of doubt in your mind. Whether it's reasonable doubt or not, that's up to the jury to decide. But I could now see why the prosecution didn't ask the question. But then there's the question of why the defense didn't ask why didn't ask that question. The defense didn't go into it at all. And part of that probably came from what we saw at the very beginning. So let's start taking a look at a little bit of today's testimony, because at the end of the day, with the medical examiner, I'm sitting here with a lot of questions. And I'm thinking that and hoping the defense is going to at least take the opportunity to clarify some of these things or try to make points of their own. So Maggie heard the shots and ran towards it. I can see that being feasible. But again, the trajectory and location of the shots leaves me with questions. It leaves me with questions. Poot was grandstanding instead. He kind of was. This kind of drove me freaking crazy. Like, you start the court day, and let's go ahead and get to this. So let's stop this one. Let's pull up today's trial stream, and y'all bear with me because it's going to take me a minute, because honestly, full day of trial, then getting into this. I'm glad I'm doing this because I need to do these recaps, but I also don't want to run into too many other people's time spots. So I kind of want to do this thing pretty quickly and get it out of the way. So this was the beginning of today in court. And here's the problem. The problem is that Dick Harpootlian is the one that's doing the cross-examination. Yeah. And for those of you guys that are here for the first time, or if you're here back, you'll notice that there's a Nightbot in the chat. Nightbot is a bot. We're still working on getting him situated, him or her. I don't give whatever we'll call Nightbot. We're still working to get Nightbot in working order so that he or she, whatever Nightbot wants to affiliate as or associate as, is not hitting people unnecessarily. So just take it easy on Nightbot. Nightbot doesn't have thoughts or opinions. Nightbot just does what we programmed him to do. So when the programming causes him to hit people, it's my fault, not his. All right. And this is a theory. So here's a theory. I like this one. Alex was kneeling when he shot. It's possible. I guess it's possible. But then explain the upward trajectory on the other shots. That's the problem I'm having. Explain the upward trajectory on the other shots. How are we getting there? And what the state has introduced, they introduced the medical examiner, but I think that they could have gone a little bit further in trying to elicit some more productive testimony as far as how the shots would have taken place. So let's see how Mr. Harpootlian decides he wants to begin the court day.
They bring the jury.
Ooh, good question. Hang on, right here. Where is it? No, don't. Chat's moving too fast. Shotguns have limited loads and may have only had 2 shells, so he grabs the other gun. Yes, except for that would have made sense if it's a break action, which I think it might have been, period, based on where the shells are relocated, but not really if it's the Benelli. The Benelli has a larger capacity to that. So I don't really buy that as much with the Benelli. But let's see what the jury. Let's see. Let's try to meander with Dick Harpootlian. Okay, come on, guys. Mr. Harpootlian, please get up and give your cross. We'll watch Dick at 1.5.
Thank you. Good morning. Day number 17. Cross-examination. Yes.
Day number 1.
Good morning, Dr. Reamer.
Good morning.
Let me at the outset say we're going to be yesterday as we went through direct, we saw some very graphic images, and I apologize, but we're going to have to do that again today. You, of course, this is what you see every day, but I'm sure you understand how other people may, especially people related to the deceased, might react to that.
Of course.
Now, let me also explain at the outset, until I read your autopsy report, I had never really considered the mechanics of a shotgun or an AR-15 or blackout impact on a human body. So I'm learning even as we speak, and I hope I can learn some things today that help me understand your opinions, and also help me understand what may have happened or didn't happen, okay? So if I ask you questions that seem simplistic, my understanding of this process is somewhat basic. So I'm going to try to walk through this in a way I can glean what the evidence is and what your conclusions are, okay?
Absolutely.
All of that was objectionable. Every single thing that came out of his mouth was objectionable. All of it. You don't get to give a monologue. Where was the question? There wasn't a question. That was just a whole, please let me be endearing to the jury. And Creighton Waters does it too. I have not found 2 attorneys that I don't think I like less than than Creighton Waters and Dick Harpootlian. Look, I didn't realize about the mechanics of a shotgun or of an AR style rifle. What? How are we getting to the point? There was no point. That was just a monologue. Just what? So that was his prelude to, I'm going to cross-examine a witness that I know is not going to be favorable to my position. And he goes through that entire thing to kind of just come off as, I'm just a low country guy. I don't really understand all of this stuff. I have zero doubts that he, as a former prosecutor, knows how these firearms work. He is just trying to play for the jury. And it's not a great start. And the witness was already on the defensive, knew essentially this was going to be a nasty cross, and it gets nasty. So then he wants to start introducing exhibits.
So tolerate my somewhat sophomoric approach to this, if you would. Okay?
Of course, and I'm sure you'll be fine.
So let me understand, first of all, let's talk about Maggie for just a minute. And were you shown photographs of the back of her thigh that were taken at the scene? The
No,
back of her calf, I'm sorry.
I did not.
Okay. So let me see if I can find these. And it'll take me just a second. I thought I had them laying right out here. Thank you for your indulgence. One moment.
Dick, this is your first question. This is your first question for this witness. You're going to tell me that you didn't have that document ready to go the second that witness was called, and you knew exactly where you were going to go with the question? Now, he makes a decent point, but he does it while also we're going to call it a little bit shady. Creighton does it too. He makes the comment as he's sitting there making an insinuation of the photos from the scene. And you guys see what he did there. He left the photos sitting right there on the bench that's right there in front of the jury. And he flips through them gently and says, I apologize. I must not have it right in front of me. You damn well had it right in front of you. You know damn well you had it right in front of you. So what he does is he's sitting there. He suggests to the jury that, we didn't hear a lot of testimony about photos. Watch me flip through the photos. Maybe you can see one or two of them. And then I'm going to leave the photos in a place that's purely visible to you without any indication of what photos on top. So we're left to speculate what photos on top. We're just not going to do that. And I'm going to walk away. So the jury doesn't have to worry about, me being the attorney making eye contact with them. The jury is free to peruse the photo that I left sitting on top of that pile as long as they'd like, as long as it takes me to get back over to the bench so that I can pick up the other photos that I intended to use from the very beginning. Mr. Harpootlian, I see what you're doing, sir. I see what you're doing. Prosecutor hasn't objected yet. Creighton Waters looks like he needs another cup of coffee in the morning. So that's kind of how we begin. And Dick Harpootlian goes back and forth with Dr. Reimer over quite some of this testimony. And I'm going to give you a synopsis of the testimony because I do want to get to, and I want to focus a lot of tonight on essentially the thing that I thought was most interesting, which was towards the end of today, because we didn't get a whole lot today other than realizing that Mr. Barber, the defense expert witness examiner, or the person who's been charged with examining a lot of these expert witnesses, the gentleman right there, Mr. Barber makes a good mannequin. When did lawyers start becoming mannequins in trial? Is this a new thing for me? Like, I have not seen it before. Do we not have mannequins we can bring in anymore? Because yesterday we had Creighton Waters walking and crawling around on the ground. And today we have the defense, one of the defense attorneys who's taken his coat off so that he can go and display everything out for the jury. It's effective in that it shows a human body and it shows the angles a human body can contort to. But it's one of those things like, really? This is where we are? This is what we're doing right now? So Mr. Barber makes a good prop.
Comes through, and that was buckshot that you shot with in the chest.
Yeah, it was shot. We don't remember the exact size. Right. Buckshot is usually bigger, but
Okay, assume I'm not misleading you. Okay.
Right, some shot.
Buckshot goes through and hits the back window.
Uh-huh.
That leaves holes in the window and hits in the door, the window frame, and goes out. One of them embeds in a tree back behind. So that is consistent with your findings, correct?
Yes.
That first shot. I'm sort of intrigued. Is there anything about the exterior of this shot? What's beveling? You know what a bevel is, beveling?
Yes, of course. Beveling is a pattern of defect through a bone. So when there's a gun.
All right, so at least we've got Creighton Waters who's woken up. He's had his second cup of coffee. He's up and he's paying attention. And we've got some good points. Well, I'm going to say good points. The only points that I think that Dick scored today was essentially the height issue, the shot trajectory issue. Those 2 points, those are the ones he needed to score. He needed to score the issue on basically the fact that the gun was fired upward. The fact the gun was fired upward. He needs to make that point emphatically, but he needs to do it in a way that doesn't get an asked and answered objection over and over and over again. So he does it in different manners of essentially saying, well, what if it was this shot or what if it was this shot? And he keeps on pointing to Mr. Barber's shoulder and gives the upward trajectory to try and re-insinuate to the jury that this was upward trajectory. And then he goes in and he makes the other point of distance. Now, Mr. Harpootlian makes 2 comments that I thought were kind of curious until I realized where he was going with it. The medical examiner yesterday testified 3 feet, 3 feet, 3 feet, 3 feet, continuously repeated the 3 feet thing. Dick Harpootlian made the comment of 3 to 4 feet, 3 to 4 feet, 3 to 4 feet, over and over and over and over again. I was going, why is he making this seem like it was further distance away? Doesn't that actually hurt his case? And then I realized that what it was he's not really suggesting the 3 to 4 feet. He's doing that to try and get the ME to say closer, closer, closer. And the ME doesn't fall for it. The medical examiner does a good job. Because if the medical examiner keeps on saying it was closer or something to that effect, then it starts to lead into his next argument, which is essentially the suggestion, at least for a part of the morning, that there was a self-inflicted consideration in some of these injuries. Why are they arguing the possibility of self-inflicted when there's 2 shots? I know that the investigators when they were first on the scene, they wanted to turn Paul over to see if there was a gun underneath, on the thought that this might have been Paul shoots mom, then Paul shoots self. I understand that part. What I don't understand is why you stick with that argument once you learn there were 2 shots. And are you just trying to poke a little hole here and there to figure out whether the jury can follow you along in any of this? It was really kind of annoying to cast doubt. Yeah, but the doubt has to be reasonable. And if someone is telling me that it was a self-inflicted wound, that's a good one. People have asked the question of what is reasonable doubt? A doubt is reasonable when it has a reasonable probability of actually being a thing. You have to go beyond simply speculation. You have to go beyond simply something that cannot have occurred. And the idea of this injury to Paul being self-inflicted, that I think is right there in that realm of an unreasonable doubt. Because the idea that someone would be able to take a shot that they inflicted on themselves to the shoulder and arm, and then take a second shot that came from the trajectory that was from the outside of the body upward, outside of the shoulder upward through the back of the head, that is not a reasonable doubt. So that's not a reasonable probability. That doesn't have the possibility of being an actual thing. So again, I didn't really see where he was going with this. It got into a lot of sparring. What Dick ultimately ended up doing was he was successful in frazzling the medical examiner. She did get a little testy with him. I don't know that it really worked out too much in his favor because a lot of it was she had endeared herself to the jury prior to that. It is just me speculating because she was testifying pretty well yesterday. It did lead to a funny moment in court where Harpootlian makes the comment to people can disagree, and medical examiner says, well, people can disagree, but that doesn't change the truth. That was interesting. And then at the very end, Harpootlian walks back after redirect or recross and basically says, but that's just an opinion, right? It was a little shade. I don't know that it got there. I think you're going to see contrary opinions coming in. The other thing I thought was interesting was the medical examiner, which I thought was a flaw on the part of the state. The medical examiner was pretty adamant that she had not reviewed a lot of the images from the crime scene. I understand that she's a medical examiner. Her role and duty is to assign cause of death and to identify the cause and manner of death. However, with the scene laid out the way it was, I find it a little odd that the state wouldn't at least show her the scene or show her photos of the scene to show the layouts of the bodies, where what she's saying when she's testifying yesterday about Maggie being bent over, the possibility of her being bent over and taking the shot through the chest, the one that entered up into her head, that shot would have come from her being bent over if she had not seen how she had laid and fallen at the scene. So not having those does a little bit, at least from the suggestion from Mr. Rapulian, to possibly undermine her conclusion as to how these things happened, rather where the bodies were when they occurred. So that was kind of interesting. I thought that was interesting. And then, forgive me, let's go through, we get through all of her testimony. It takes almost all of the morning session. Think we're going to be done. And then we get Mr. GM. Where are you, sir?
Witness.
State calls Devin Newell.
Devin Newell is the custodian of records for GM. His testimony was rather simple. It wasn't really significant. Honestly, because, well, the only thing significant about it was kind of the first things he testifies to.
Your present testimony about the report in this trial, have you repeated that for Michael?
Devin Patrick Newell, Newell.
All right. Good afternoon, or excuse me.
Good morning, sir.
Mr. Newell.
Good morning.
All right. Where are you employed, sir?
General Motors.
All right. And what are your duties there at General Motors?
I'm a senior technical expert in advanced driver assist systems.
All right. And can you just give the jury a very short version of what that entails? Very short, please.
No.
I investigate field performance issues and concerns with our advanced driver assistance systems.
And as part of that role, do you help maintain certain records that are kept by GM in the normal course of business?
I don't necessarily maintain those records, but I'm aware of records that we keep on servers relative to vehicle data that can be of assistance in
Speak
field
this up a
performance
bit.
investigations.
And when you say field performance investigations, that's something you do, correct?
That's correct.
And that reference is generally what? What does that mean when you say field performance investigations?
Understanding how our vehicles may perform in the field, active safety systems include things like forward collision alert and automatic emergency braking. So as we look at how those things perform in the field, vehicle data and other data we collect can be helpful in understanding what is occurring with those events, understanding how our systems are performing.
Okay. And do modern GM vehicles, under certain conditions, upload information to GM servers?
That's correct. We've got telematics units in our vehicles. That's a fancy name for sending information over the air. Those, as part of a normal course of business, those electronic modules in the vehicle collect lots of pieces of data from different sensors and modules in the vehicle. And that information can be sent by cell phone networks and or Wi-Fi back to servers at General Motors.
And General Motors then keeps that information in the course of normal business, correct?
That is correct.
Now, if someone buys a GM vehicle and they're not comfortable with uploading certain types of information, can they opt out of some of the things?
Certainly.
Oh my gosh. Okay. I'm sorry. The accent, it makes it too fast at 1.5. And honestly, his testimony is kind of a nothing burger. The things that we learned from his testimony is basically that GM found out on Friday being, yes, 3 days ago, that there was an outstanding subpoena and that information hadn't been provided. Not just a subpoena, this is a search warrant. This is the government coming in and saying, we want to search your information. And GM just magically discovers on Friday, in the middle of trial, at the end of week 3, I want you guys to keep in mind, if this trial had actually been 3 weeks in time, this would have never, ever come up. We never would have seen any of this information because GM wouldn't have gotten it. Or ostensibly, they wouldn't have seen that the information hadn't been provided. So on Friday, they find out that it hadn't been provided. I imagine that someone in their corporate office was rather upset that their name was being besmirched and that the FBI had to try to crack the encryption that they use on their software, and that you had SLED essentially create a skimmer that skimmed the information they were able to glean off of the unencrypted OnStar data to try and translate what the hell that actually meant. This would have been so much easier if OnStar had just cooperated with the search warrant. Who the hell knows? Doesn't really matter. OnStar information is it's in evidence. They authenticated it. It's there. It's now going to be left up to somebody else to basically lay this out. My theory is it's going to be the timeline guy who's going to try, or gal, who's going to try and streamline all of this to make all the different timelines make sense. So we'll see how they end up using it. It didn't seem like the defense was too afraid of this information. I don't know what it's going to say. My curiosity was what type of information this stuff includes. I understand that it includes speed. I understand it includes the vehicle status. Does it include additional information? For example, is the window rolled down? I don't know if it would have that data or not. Honestly, I haven't run across that. I'd be curious to find out if it had that information or that capability. That might have been something I might have asked if OnStar had the capacity to recognize that. Or even if I'm the defense, to suggest that the OnStar data might have the ability to track if a vehicle slows to a certain speed and for how long they're able to detect that information. For example, if I'm in a car that has OnStar or this data collection and I suddenly stop, well, we know that OnStar collects that information because they have crash collision detection. How about if I slow my vehicle down to, 30 miles an hour from 45 miles an hour? Can they detect that? What if I slow it down to 10 miles an hour and possibly roll the window down? Can it detect that? I'm not sure. This comment's good. Maybe exact GPS. Maybe. But how exact is that GPS data? There's a margin of error with that. So can you really detect the vehicle speed with that margin of error? I don't know. We'll see. But again, we're going to see with that. So, and then I do see people making comments. If you guys are getting blocked out by Nightbot, please I try to ignore it. I'm sorry. We'll try to figure that out. Still working on it. So that was the totality of the GM expert's testimony, was basically say, we are going to basically just authenticate the records. They're coming into evidence. They're in evidence. What they do with it, who the hell knows? We got information to go. Then we have Mr. Roger Dale Davis. I called him the dog whisperer because his role in the property was basically to care after the dogs. So he would appear on property very early in the morning. He would hose and run off. He would hose down the kennels. He would keep the dogs well maintained. And he seemed to have a lot of information about the dogs. The most that I took from his testimony was twofold. The state wanted to get two things out of him. The information the state wanted to get out of it, well, three things. The state wanted to get three things out of him. One, that the hose was not how he left it. That the hose was on the ground, or the hose had been taken away from its perch as normally kept. Two, that the dogs were placed back in kennels that were inconsistent with how Maggie usually placed them. And three, that he was in fact asleep at home on his recliner at the time of the murders. So those are the three things they wanted to glean from him. What we gleaned instead, that I thought was rather interesting, was that these dogs have some of the coolest freaking names I've ever heard of. You have Grady, Bubba, Cash, Armadillo, and Tappy Toes. But I think Tappy Toes is just a nickname for Bubba. But these are the dogs. Dogs are pretty cool. And that the dogs wrestling with the chickens was a normal thing around the property. And it became worse with the introduction of the rooster, who liked to tease and torment the dogs. Last thing that the prosecution wanted to get out of Mr. Davis was that Bubba would listen to Alex when it came to commands. So that was the evidence we got from Mr. Davis. Also, that the guns around the property were kept in a side-by-side within the trucks. They were kept within the ATVs. They were basically a gun. If you were on that property, you were likely to stumble across a gun. There was not a gun down at the kennels the day that he was there in the morning. And that Alex, I thought this one was interesting, that as far as his observations, Alex preferred to drive his truck, his F-150, rather than the Suburban. People made a comment about the gun that Alex would keep in his truck or in his car. He said that he would keep it in there from time to time. It wasn't always consistent. And then that made me ask the question of, well, what car does he keep it in? Because if he's keeping the F-150, but he's driving the Suburban that night, that's different. Going to the end of the battle between the dogs and the roosters, or the dogs and the rooster apparently would sit out front of the kennels of the dog and taunt and torment these dogs and get them all up in a ruckus, and that caused the dogs to go after the chickens more. But in the end, the rooster got his. One of the dogs took it upon themselves in a very grand gesture on behalf of the other dogs and took the battlefield commander for the roosters off of the scene. So the rooster died in battle at the hand of one of the dogs. So Bubba got a little bit of reprieve. Yes, I see uncivil. Rooster is guilty. He was adjudicated guilty by combat. He was unable to prevail in the fight against the dogs. And as a general, while he did well to coordinate and maneuver his troops, he ultimately suffered a defeat at the hand of the enemy. He swore to taunt and torment at all times. Rooster was just way too cocky. I see the chat. Y'all are just something. Y'all are something else. This was the other part. So as we're walking through here, we're seeing some of the pictures. The defense walks him through some of the photographs. Let's walk.
Then let's see.
Yeah.
Yeah. And then it would be tappy toads. That would actually still.
So they're the kennels. Just
All
to give
right.
you the
Did
idea.
water ever pool over by the feed room?
No, because usually that's the reason I would go in the afternoons, the sun would come down and beat. It would dry it up a lot quick. Especially in the summertime, it would really dry it real quick. In the wintertime, the sun would actually still hit the concrete around 3 to 4 o'clock. It'd be usually around 6 or so before the sun wouldn't be hitting on the concrete.
Did water pool in the front of where Bubba would have been located or Grady?
No.
Showing you State's Exhibit 503. Dale, are you able to see the water located near the feed room and in front of the two kennels, 1 and 2?
Okay. So this is one of the first times we actually get one of the photographs of the actual feed room. Now, I want you guys to recognize this is a crime scene photo. There is what you're seeing there is where Paul was. That was where he was located when he was killed. So this is kind of the proximity, and this is what leads me to some of the things that I was asking about with regard to the two-gun theory, or the idea that this was pulled off by a single shooter. There's the feed room, upward trajectory towards Paul, then Maggie is located around the corner. And the feed room is right there, located next to and abutting the kennels, so the dogs are right there. I don't know how all of this actually occurred. I'm going to be very honest with you guys, because I need someone to put it together for me. I need the prosecution to lay it out with these photos and actually make a closing argument that is unlike what they have done throughout the entire trial, which seems to focus on finances, then back to timeline, then back to shooting, then back to finances, then back to motive, then back to all the other things. This closing needs to be organized and consolidated in order to get anywhere close to beyond a reasonable doubt. And I don't know that they can get there with the evidence they have. And again, caveat, this is beyond a reasonable doubt that Alex Murdaugh pulled the trigger for every one of these shots that they're accusing him of pulling. I still have questions. I'm not there yet. So we're still going to try and figure this out. So as far as the hose is concerned, the hose wasn't where it was left. But in Paul's cell phone video, where he's taking a picture of Cash and sending it to his friend Rogan, you see the hose in the background off of the hook where it was usually kept. The hose was already down. Not only that, but in the background, you hear the hose being sprayed in the background of that video. So I'm wondering how much bite that evidence has to the defense's case. We shall see. As far as the dogs being put back in a different order that Maggie usually liked to keep them, from the perspective of the defense and the questions they were asking was that, there were times that dogs went into the different kennels based on all number of circumstances. If we're trying to talk about what a reasonable doubt is, the idea that dogs are not in the kennel that way that one of the people preferred them to be, it's a reasonable doubt. That's one that kind of gives you a reasonable alternative to the one the state is trying to infer. So that was kind of my synopsis of Mr. Davis. Now we go forward to, I'm going to skip over the forensic accountant because, of course, they put on this guy who's honestly, I'd love to have a beer with this guy. He's pretty cool. Probably one of the most personable witnesses of the entire trial. I don't know that the prosecution scored a lot of points. I don't know the defense did either. And then the prosecutor, after this wonderful witness, he throws on Carson Burney, the forensic accountant. Oh, good. We're talking about money again. During the course of this, the forensic accountant talks about how money was owed and how Alex was in debt and how he was unable to pay the money that was owed around this time. During cross-examination, Jim Griffin, I think Jim handled the cross-examination this one. Just fast forward, make sure I can see his face. I think Jim handled the cross on this guy. Oh, look, there are Kurt's favorite characters, the seal clock and chandelier. To the mix, we have added Rooster, Chicken, and Bubba. I think Bubba has since been vindicated. Bubba is no longer on the hook for these crimes. Rooster, I think, has predeceased the crimes, so I don't know that we're there. And no, it was Dick Harpootlian that did the cross. Or was it? Or am I just mixed up on my time? Come on, Law and Crime, do better. No, it was Jim Griffin. Jim Griffin does cross. During cross-examination, Jim Griffin makes the bold statement of kind of going, well, wasn't he able to borrow money from Palmetto Bank? I say this is a bold strategy. From the legal perspective, great question to ask. From the pure prejudicial element, maybe don't insinuate that the whole like fraudulent loans from Palmetto Bank should completely acquit your client. However, he makes a good point. The point he makes here is that Alex Murdaugh, at this point in time that these murders are being carried out, the whole Palmetto Bank indefinite piggy bank that he's allowed to access, the credit card with no limit, this has not been discovered yet. He is still able to pull connections, ostensibly in the defense's theory, with Palmetto Bank and draw funds that he might not have available to him. So Griffin starts treading down this territory, and I think scored a point here and there. And it also brought up the point that a lot of Alex's property was somewhat illiquid. He owned a lot of property, real property, homes, land, and that for the usual person, those things are hard to monetize. They're hard to liquidate. And that was where the state on redirect kind of bothered me a bit, because the state on redirect starts asking these questions and making the comment of, rather the state attorney, the prosecutor, asked the question of this witness, Mr. Burney, and says, have you ever bought a home? Have you ever sold a home? And the process of selling a home isn't that difficult. Well, that's not relevant. And it's also speculation. It doesn't have any impact here because Mr. Burney's finances are not that of Mr. Murdaugh's. Mr. Burney might have sold a home, and it might have been difficult for him to obtain the money out of the home, get the equity out of the property. But that doesn't mean that it was difficult for Mr. Murdaugh. Mr. Murdaugh has demonstrated time and again that he was able to leverage the property and get money out pretty quickly. That it didn't really require a whole lot more than a handshake for the bank to give him money that he would later promise he would be secured against the property. So I thought this was an objectionable line of questioning, but the defense let it go in. The defense let it go in without too much in the way of objection. I don't know that it did much. Again, finances. Now we approach the actual fireworks from the day, which this trial gets crazy. But before we do that, let me catch up a little bit here. So, Janie Wallace, thank you very much for sharing the hearts between EDB and you. It's been a tough emotional day for me. As VD, if Mom was still alive, her and my dad's anniversary. I'm very sorry to hear that. I hope that you can still try to celebrate that. Thank you for the distraction. It is a distraction. Enjoy the preview and the recap of today's wild testimony day. And I'm sorry for that. That's a tough day. Haley from Marion, glad for a wellness check-in after court today. Happy V-Day, Pickleman. Okay, yeah, it was a wellness check. That works. Clever nickname. Can you do the triple extentation trial on Friday Night Frenzy? It's spicy. I'll see if I can play catch up on that. That's a good idea, though. Began, Wigan, thank you for the super sticker. Stephanie H, happy Valentine's Day, everyone. Happy Valentine's Day indeed. Rebecca W, if I hear shots and my son is down, I'm going to him. That is the consensus that I see from a lot of people as well. Chrissy Lee, thank you very much for the super chat. Thank you for doing it informative. extra stream. It's already been helpful after I missed so much. Wanted just to show my appreciation because probably won't be able to do super chat for a while after this month. Chrissy, you never have to do that. You can send a regular chat. You can also I do see your comments. Thank you for being here. I hope that this is helpful to do a brief recap. Buffy Lynn, thank you much. Asked gun owner family if possible to shoot 2 people with 2 different guns. All said immigrants said yes. Easy. So happy Valentine's Day, Robin, all chat peeps. But within what time? That's my question. I'm always curious about that. Ashley Nicole, thank you very much. May have missed it, but were the dogs out and then put back after 911 call? Who put the dogs up? From everything that we've seen, the dogs were put up when officers arrived on scene. We don't know when they were put up in the kennels. We don't know by whom they were put in the kennels. All we know is that when the officers arrived on scene, the dogs were in their kennels. Barbara Rule, thank you very much. Rob the Mob Crew, YouTube, RE enacts a shots to scale. I'll have to check that out. I'm very curious about that. KC Cat, thank you. I found it interesting that the most damaging info that has come in is because Poot keeps kicking open the door. That we're going to get to in a minute. Poison Elf, thank you very much. Obsequious, toadying, bombastic, snake oil salesman. I got to learn that first word. I like words. I need to insert that one into the grammar. Haley, thank you very much. We just moved from Maryland to this area, and I'm 98% sure his bumbling old man act will not play well to these people. It's offensive. I don't know. Baby Gator, Poot, poor me. I don't know what I'm doing. Also, Poot, look at me. I know more than the ME. It was pretty quick. He knew what he was doing. And he got going. CMS, thank you very much. For everyone who's feeling lost and lonely this Valentine's Day, don't forget you are loved and you are not alone. That is absolutely correct. You guys are here. We're all hanging out. We're having a great time on this Valentine's Day evening, recapping some of a trial that I am begging to start making sense at some point. And I would beg for the attorneys to please help us make it sense. Please help us make it sense. You see how much it didn't make sense? The sentence I just said to say how much it didn't make sense. Please help us make this trial make sense. The number of questions that this trial still has outstanding is driving me crazy. And the number of people who are so mad that I still keep having these questions are also I'm trying to give you guys an honest assessment of what I see as far as the evidence is concerned. It's just difficult. Kathleen, thank you very much. 12 square foot space for demonstratives. At Elmo, people have to crouch down to use a monitor sitting on the floor, and 5 to 8 attorneys milling around makes this a ridiculous circus. On that, we will 1000% agree. You have no place for demonstratives. No one can see anything or use any of the tech. The monitor's on the floor. You have the attorneys that are milling around everywhere. And for the love of somebody, can someone teach them how to unsheath and organize papers without hitting the microphone every freaking time they turn a page? Just please. It can't be that difficult. Sarah Lee, can we address why the blood expert was allowed to thumb through her notes for every question? How is that allowed? You're allowed to testify based on your report if the proper foundation is laid to allow you to access that report. Generally speaking, an expert will say from the stand, may I please review my notes? And that is generally speaking allowed because they're not expected to memorize every single percentage and number that is in their report. They're allowed to go back and reference it. Melissa, thank you very much. Check the Mob Crew for reenactment of shooting angles. I'm going to have to do that. I'm going to have to do that tonight. Jeanette, thank you very much. I think Tappy Toes was Cash. I think you might be right. Lauren L. motion to name the pickle Armadillo. Motion seconded. Didn't Maggie's footprints show her walking away and then turning and walking back? I think she turned back to see what was being shot at, and that's why the shooter was close to both Paul and Maggie, 3 feet. That's real close, especially if someone's holding a gun. I'm not saying you're wrong. I'm not saying you're right. I'm just saying I have a question and I need someone to tell it to me as if I'm a juror sitting there asking the same question. Della, Sandra, thank you very much. Appreciate your knowledge and love your positivity. Thank you, Della. Very much appreciated. Veronica, what would happen at the trial is if someone confessed that Alex hired him to kill them? Well, wouldn't that be a wild day? honestly, I think what you would probably have, you might have the state fighting that. I think you'd probably have the state fight that. This far into the trial, the state's going to try and tell the jury that he's a liar because they're going to stick with they have to stick with their narrative. They have to. Lisa Castle, thank you much for the super chat. Very much appreciated. Okay. Let's go into the brief beginning of this testimony, which is unfortunately handled by Creighton Waters. Here for years, I see that comment, and I thought that initially too. If someone gets on the stand and says, I did it, he paid me to do it, technically speaking, the prosecutor could move for a mistrial. But if they did, they would have to bring the case all over again, and then they would have to explain why they're giving a completely different opening statement, why the evidence means something completely different than what they relayed it as meaning in the previous trial. They are too far along in their case to lose that traction. They cannot give up on this narrative at this point. So would jeopardy have attached already? Not to conspiracy. I think Kurt did a great job of explaining why it wouldn't, uncivil law. So I think conspiracy would be a different charge. So let's see. So this.
Sit right up here, state your full name for the record, spell your last name, and then move the microphone where they can hear you. Okay?
Marion Proctor is the sister of Maggie. This is the first time that Maggie's family's been in the courtroom the entire trial.
I'm Marion Proctor, Proctor.
Good afternoon, Ms. Proctor.
Hi.
Go ahead and tell the jury, do you have any relationship to Maggie and Paul?
I am Maggie's sister, and Paul is my nephew.
Can you pull that mic just a little bit closer or slide your chair up just a little bit so you don't have to lean forward?
Okay.
And is that a fresh bottle of water there?
It is.
Oh, it is? That's your water?
Yes.
Go ahead and, if you would, tell us a little bit about yourself, just where you grew up and just a little bit about yourself so they get to know you just a little bit, please.
Okay. I grew up in Wilmington, North Carolina. Maggie and I did. She was my only sibling with two parents. And we both went to college, both married, both lived in South Carolina. We've been here ever since. I'm married. I have 3 daughters, and we live in the Charleston area.
Where did Maggie go to college?
South Carolina.
Did she go somewhere else and then transfer to South Carolina?
She did.
Why is a lot of this relevant? I'll get to this in a minute. I'm gonna let this run for a minute, and then I'll be like, I'm gonna give a critique, and then we're gonna fast forward across. So I'm gonna let this run for a minute, and then I'll give a critique on some of the direct questioning, and then we'll go to cross.
How far apart are you and Maggie?
5 years.
And your parents, what are their names?
Terry and Kennedy.
And do y'all have any other siblings, or was it just you and Maggie?
It's just Maggie and me.
Growing up, being 7 years apart as younger folks, was that a bit of an age difference as y'all grew up?
It was. For children, that's a lot. So, I was in college. She was in high school. So we weren't super close when we were children, but later on, as our lives became more similar, we became very close.
And how long ago do you think that relationship grew very close?
When the children were little, we did a lot together. It was easy. As they got older with, their commitment, sports and things like that, it was mostly holidays, Christmas, Thanksgiving. And then when we both became empty nesters, we were having a really good time.
Y'all talk almost every day?
Almost every day.
Tell the jury a little bit about Maggie. How would you describe her as somebody, just so they can get an idea of who she was?
Maggie.
Okay. I'm going to give my critique of Creighton Waters here. And this is one of the frustrating things I find with him and Dick Harpootlian. This is a trial critique, and this is something that I've made a comment about throughout the entire trial. Your job as a lawyer is to ask questions. And you have to ask questions in a way that elicits the answer without making it apparent that you're guiding the witness towards a certain response. and without overrunning the witness and taking the stage from that witness. The stage is supposed to be Ms. Proctor's. It is not supposed to be Creighton Waters. And when you're asking questions in this fashion, you're both signposting to the witness the response you want them to give. You're not letting them actually navigate their own story. You're putting her up there and you're basically pointing to a certain thing that you want her to respond to, but you're also just overrunning her when you're doing it. And you're not listening to the answers. She answered to you. She answered you. They were 5 years apart, not 7. You repeated that incorrectly. Creighton Waters has this thing of going in there and asking questions that he hopes will distract the jury from the point he wants to make. It's something important. When you're a lawyer and you have a witness on the stand, you can't just go right in there and just start hammering away at the points you need that witness to make. You have to establish a rapport. You have to establish a reason why the jury should care or why the judge should care if it's a bench trial. And you have to do that in a natural way. You have to let the witness talk. You have to say open-ended questions saying, tell me about your childhood. And he does that to a point. But here's what he does. Tell me about your childhood, but then go ahead and fast forward. Was it different being 7 years apart after ignoring the 5 years? Well, that doesn't really let the witness tell their story. Well, did you go to college? Did your sister go to college? It's like 3 or 4 questions. Back off, slow down. Let the point that you need to make naturally develop. This feels rushed. Every single time it feels rushed. And he's not the only one that does it. Dick Harpootlian does as well. We all know you want to get to your point. We know you want to get to this witness's testimony. Not this part, because the other part this does is this tells me he doesn't care at all about the responses. He wants to get to his point. That's why he's sitting there with his folder across his chest. He's not looking down at the questions he wants to ask. He wants to get to his point, and he would like to get through this cursory introduction before he gets there. I'm sorry if I'm venting a little bit, but as a family law attorney, this drove me freaking crazy. When you put a witness up there, you have to let them talk. If you're putting them on direct, you have to navigate them, but you have to do it without feeling so freaking obvious to everyone in the room that where you're trying to get. Just take a step back, Creighton. Now he does a little bit better. He slows everything down. He really slows everything down. And towards the end, I'm focusing on direct because I'm going to get to cross in a minute. We're going to play more of the cross, but I'm focusing on direct. In the end, during direct examination, here's what Creighton Waters elicited. These are the bullet points that I thought were important. That Maggie didn't want to go to Moselle, and that it took Alex convincing Maggie to go to Moselle. This point gets brought up on cross. I don't need that you need the cross. And then most significant was the conversation after the murder when Alex made the comment to her that said whoever did it had thought about it a long time. Well, that doesn't really prove a lot. It's just suggestive. And if you buy a lot of the other suggestion, yes, it's suggestive. You get a whole lot of creepy out of this trial. A whole lot of creepy out of this trial, but you don't get a whole lot of this is how it was done. And then the number one goal for Alex Murdaugh after this one was to clear Paul's name in the boat case. Again, creepy, but not direct evidence. Creepy, but doesn't prove a lot. This trial is a whole lot of creepy, a whole lot of Alex Murdaugh, bad guy. But look at the issues that I'm trying to focus on. The questions that I have aren't whether Alex Murdaugh is a creepy, bad person. I figured that shit out. It didn't take me long. Honestly, it really didn't. You could have put one of those financial witnesses up there. It wouldn't have taken me long. Hell, you could have let me just speculate on all of it. I would have gotten there. But where I'm having trouble is the last little tidbits. And here's the problem that the defense has with this. The problem the defense has is that while this is me as a lawyer critiquing the facts that are in evidence, juries don't always operate that way. Juries don't always operate to basically say, I'm going to view the facts surrounding the shootings in a bubble. They are going to look at the facts, and they're going to look at the person, and they're going to pass judgment on the person. They're going to say this person was capable of doing this. And the more evidence they get that is suggestive of some nefarious background or motive or suggestion or how terrible he is, I'm not disputing any of that. But the more that they do that, the more it weighs in their mind when they're sitting in judgment of another person. And if the facts don't line up, the more that they hear that's of this nature, financials, drugs, the creepy statements, different things that he's doing, the more that they hear in this one, the more that they're inclined to disregard what might be an inconsistent fact. The more inclined they might be to disregard a timeline issue, or heck, not saying it's there, a second set of footprints, or heck, GPS data that doesn't line up. You have to judge based on how the state has charged this case. You have to judge based on the facts that go towards that charge. So we're going to go to cross-examination. At the conclusion of her direct examination, there's Jim. All right, the conclusion of her direct examination, I had one resounding thought. One resounding thought. Do not cross this witness. Pass. Do not cross this witness. The damage done was rather insignificant, and only thing you can do by crossing this witness at all is to get yourself in the weeds. You risk alienating the jury. You risk alienating the jury by pushing them away, by taking on a absolutely sympathetic witness. Two, the points you're going to make are difficult to make. They require you to do a whole lot of questioning so you're not alienating the jury. And essentially, last part, risk reward. For every minute that you have that witness on the stand, every question you ask, especially in a freaking trial like this judge wants to let all the evidence in. At this point, the judge has showed his hand. He is going to let the evidence in. Do not crack the door. Do not jiggle the handle. Do not even stare at the door long enough. You know this judge. You've been in front of him for 3 weeks. He has done enough to establish what his desire or his preference is in this trial. It doesn't make it legally right. I'm going to say I disagree with a lot of the things the judge has said. I disagree with a lot of it, but you're a trial attorney. You have to understand the courtroom that you're fighting in. You have to know that this witness on the stand during cross-examination is all risk and no reward. You can prove the points you need to prove without doing a cross-examination. For example, they had a good marriage. You can prove that with other witnesses. That she frequently went to Moselle during the summer because Alex asked her to, because Alex worked near Moselle. That's fine. You can get that through other witnesses. You don't need to cross this witness. You did not need to go down this road. So I'm sitting here when Jim Griffin, of all people, and I'm not saying that like a bad thing, but if Jim Griffin, of all people, who knows this witness personally, when Jim Griffin stands up and goes to cross-examine, this is red alert, people. Like, are you kidding me? This has no good signs on it. There is nothing to gain here. It is all risk, no reward. What are you doing? It should have been a pass. And it doesn't matter that I think the judge makes an interesting call. And I'm curious about it for several different things. We'll get to that testimony. Let's get to the testimony right now. We'll just watch this bit of testimony that leads to, let's see, when did the jury get left out? It's about 5 minutes after here. So let's see where we are.
I just thought his priority should have been focusing on finding out who killed Maggie and Paul.
And how do you know that wasn't a priority for him?
We never talked about it. We never talked about finding the person who could have done it. It was just odd. And we were sort of living in fear because we thought this horrible person was out there, and we were mostly afraid for Alec and Buster, but we didn't know the motive behind the killings. We thought it probably had.
Right there. Right there. Jim Griffin, there's your red flag. There's your red flag. She gave it to you. Did you guys hear it? I'll replay it. Jim, here's your red flag.
Something to do with, we thought it person was out there, and we were mostly afraid for Alec and Buster, but we didn't know the motive behind the killings. We thought it.
She used motive, killings, and then started going down the sentence of we thought. She used the word motive, not Jim. Jim didn't use that word. She used the word motive. Motivation for the killings, and then she said the word we thought, as in past tense. We thought, past tense. Danger, Will Robinson, danger. Because at this point in time, now you have now you've got this witness who's on the stand suggesting to you that they might want to go a little bit further in testifying. And you're right. Motivation would be considered. But motivation is before the shooting takes place. What she's testifying to are things that takes place 3 months after these murders. Alex fooled everyone around him. You're right. You guys, it's driving me nuts. I'm not giving you a moral or ethical breakdown of any of this. I'm telling you from a legal standpoint in the argument here. And what I'm telling you is that as a trial attorney, when I hear a witness that's on the stand that I'm already hesitant about cross-examining, this is a red flag, and I'm taking one step back and going, how do I get out of this right now? Because she is indicating from the stand that she would like to say a little bit more about the motivation behind this.
It probably had something to do with the vote case.
Right.
And we thought that up until September.
Right.
And then things started to change a little bit.
Sure. Well, were you aware that Alec started carrying a gun after the murder? You didn't know
Alec
that?
always carried a gun.
What's that?
He always carried a gun.
On his person that he started carrying a gun. Were you aware of that?
I knew he usually had one in his car.
Right.
All right. That ends up.
I want to ask you just some sort of one topic kind of questions.
So I'm going to ask you one topic sort of questions. Jim just recognizes he's in a hole and he's trying to dig his way out. He has a witness that he's not going to be able to limit to one and two word answers. So he's now saying, I'm going to ask you one topic questions, suggesting to the witness, please give me a very limited answer. Why would you cross-examine a witness you personally know? Like, just why? You didn't have to cross her. And okay. So let's go to Creighton Waters' cross-examination. Because this is where we start to get fireworks.
Please do not discuss the case.
Wait, dang it.
September. I'm trying to figure out who killed Maggie and Paul. and then something happened in September. Is that right?
Correct,
There it is.
And that changed for you as you started to look at the motive. Is that correct? That's what you just testified, correct?
correct.
And in September, he got fired from the law firm, right?
There it is.
Correct.
And it started to come out about years and years of theft and misappropriation from clients. Is that correct?
Objection leading
Objection sustained.
What came out in September that changed your calculus?
and objection exceeding the scope of cross.
Objections overruled.
We were on our way to a football game and we received a phone call from a friend of ours saying how sorry they.
This issue that has not been ruled on.
Ladies and gentlemen, we'll have you go to the jury room. Please do not discuss the case.
So the jury's pouring out. While they're doing that, I'm going to fast forward a little bit and I'm going to tell you what the heck just happened. So there was a motion limiting that basically said anything that has to do with the certain roadside incident. The incident takes place in September, I think the 6th. September 6th, essentially, there was an incident where Alex paid Cousin Eddie, not proven yet, but it's kind of known, paid Cousin Eddie to shoot him. Cousin Eddie shot him on the side of the road. Then turns out that Alex had paid money to Cousin Eddie. This was very, very properly originally kept out of any of this discussion. The judge hadn't ruled on it yet. It was a motion limiting that said, which this judge tends to do, I will rule on it when the attempt is made to bring it into evidence. So now we are 3 months after the murder. Cousin Eddie has shot Alex Murdaugh on the side of the road. Alex is alive. God knows if Cousin Eddie's going to testify. September 4th. Thank you, chat. Yes, he admitted to lying about it and paying Cousin Eddie to do the shooting. All of this stuff was there. With that one little slip, and I don't think it was a slip. I don't know that Jim actually opened the door with the question. But now, based on this judge's history and how he rules, you know that when the judge hears it, regardless of whether you ask the question to invite it, and I don't think that's actually correct. I think the defense has to make the question. They're the ones, they have to ask the question that specifically elicits the assumed response or the response they should be aware is going to come. The whole idea that he would ask a question that says, the question was, as I recall it, we'll get to that in a minute because the judge actually goes through it. But I think that a purely legal merits argument on whether the door was opened, I don't think the door was opened. However, based on, let me rephrase that. Based on a purely legal argument of whether the defense, by their own conduct in asking a question with a response that the defense should have known would have been given to that question, did the defense's question open the door to Cousin Eddie shooting? I don't think so. Even despite the permissibility of getting into this evidence initially, because that's the dispute that we're having right now that I'm seeing a lot of people have, is whether this is properly excluded under 404 or 403 as unduly prejudicial and limited in probative value, or whether this was a door opening incident. Here's what I think the judge is going to do tomorrow. I'm putting the cart before the horse. Let's get to the arguments. Yes, this is the point. This is the point I'm going to make right here. Jim should have never crossed. Just pass on cross. It was a misstep, and we will see how significant the misstep is in tomorrow. We likely will. So let's see. The jury is excused. Oh, if you do this to me, you stream, we're going to have a problem. There we go. Jury's leaving. That's why it's quiet. I'm afraid to hit fast forward if it freezes. I don't want to freeze it. Here we go.
Nature of the objection.
Your Honor, she was about to testified that she had heard about the roadside shooting. The state has not gone into the roadside shooting yet. Your Honor's not ruled on whether that's admissible or not. We object to under 403 as to being admissible. And substantively, that is the objection, evidence of the roadside shooting. It just opens up a whole new avenue of issues. Secondly, what she knows thus far would be hearsay, which is a technical objection, but certainly we object to any evidence of the roadside shooting.
Your Honor, at this point, of course, this is responsive to a question that was raised on cross-examination by Mr. Griffin, in which he testified something happened in September. So for that reason, just to begin with, I believe that door is opened as to her to explain what it was that changed at that period in time, which was the nature of my question to her. Additionally, I think if we look beyond that, there is a connection if we want to talk and have in-camera hearing about her answer and about 403 and 404. There is a logical connection between what happened in the roadside shooting and what happened on June 7th, 2021. And that connection is, of course, that the evidence will show that.
You're not answering the question. Stop freezing. Oh, don't do this to me, you stupid internet. Don't do this to me, please. All right, I'm going to do this. Hang on 1 second. While I'm doing this, I'm going to reload this and tell you essentially what's being argued here. What's being argued here is two issues. One, whether the door was opened. Did the defense ask the question that invited the answer? Two, assuming the door is opened, or in the contrary, if the door is not opened yet, this evidence is admissible under 403 or 404. We would like to go into this topic of the roadside incident. Cousin Eddie. We want Cousin Eddie. I don't think the door was opened, but I think the judge is going to rule on 403. So that's where I'm coming down on this one. I don't think that the defense opened the door with the question. I think there's a suggestion that the question or the answer to the question probably went down that road. I just don't see how the defense is the one that did the question, or how that question gets me there. That's where I am. So, and for people saying he blew the door wide open, I want you to honestly tell me how. How does the question asking about was there fear? How does Jim Griffin asking a question of did you all have fear open the door to a shooting taking place 3 months after the murder? I'm not there yet. I'm just telling you, I'm not there yet. I'm just being honest. So, of course, we're having all the internet issues right now. Our internet issues are fixed. Internet issues are fixed. Good. Oh my gosh. Where was that stupid stream? Freaking law and crime. How does it open the door? That's my question. I don't know how it does. I understand that it goes to intentions and motivations and thought processes, but then you have to do the analysis of whether it's more prejudicial than probative. Is it more prejudicial for a jury to hear, hypothetically speaking, that this person was shot in the head by someone he might have paid? And then we'll go back to the actual question. So here we go. Now my question is, why can I not hear my own audio? Because you muted it, Rob. We can do this, folks.
And what happened on June 7th, 2021. And that connection is, of course, that the evidence will show that as the temperature increases, as there's a confrontation for Alex Murdaugh, then things like this happen. And that's what happened on September. But as it relates.
Terrible argument. Horrible argument. And I see people commenting here, another planned event. As the pressure increases, he does this thing. That's a lot. It's a lot of a stretch. I'm speaking from a purely legal standpoint. The idea that someone did something bad does not mean they're going to do the same bad thing again when faced with similar decision. It is a stretch. Let me put this in the context of me speeding. Something we can all understand. I drive fast. Always below the speed limit. Never really too fast, but I drive fast. So because I drove fast on Thursday, Friday, Saturday, does not mean that because they didn't see my car, they can presume that I was driving fast on Sunday and breaking the speed limit. Let's say that I drive fast when I have to get groceries and I have to pick someone up from something else. God, pick a fucking example, Rob. Here's one. I speed when I go to court. Let's say that you have an example of me speeding to go to court 3 times in the last 4 months, 6 months, in this case, a year. 3 times last year, I was driving to court and I speed when I go to court. Well, in June, I was, someone saw me leave the office and they saw me walk into the courthouse, but they don't know how fast I was driving going there. But then in September, because I was speeding, got caught speeding, drove too fast, got pulled over, and was going to court, that we can assume that that's what I did there. And now people are saying that's not the point. It goes to a fear. That's not the argument Creighton just made. Creighton didn't make that argument right there. The judge makes the argument for Creighton, but what Creighton argued was different. What Creighton was arguing and inferring was that essentially, because he had done something similar on another occasion, that should be used as evidence to convict him of doing the thing here right now. That is where Creighton is saying that this is just different. Or that's where Creighton is going to say, I'm sorry, I'm going to stop looking at the chat for a minute. What Creighton is saying is that when he sees a storm coming, he commits an unlawful act to ignore the storm or to keep the storm pushed down the road. That's what he has said throughout the entire trial. As a general rule, you are not allowed to introduce evidence of character to prove an act in conformity therewith. That is a general rule. The exception to that rule is motivation, that you are going to introduce this evidence to basically say this person had a motivation to do this because of this further or this other unlawful act. Where's my rule? Where's my evidence book? I brought it. Here we go. 404, 403. Drive me crazy. Because of course this is what happens when I'm 2 hours in a live stream. 403, 404. So 403, substantially outweighed, needlessly cumulative. Okay. Don't get to do it. And then to show motive, opportunity, intent. So motive, the act they're trying to get to is 3 months after the murder. That act, that decision can't show motive for his committing the murder that he's alleged to have committed. Opportunity. This act doesn't show that he had the opportunity back in June to commit that offense. Intent. Possibly, arguable. But then that would put you back into the 403 of whether its prejudicial value outweighs the probative value. Preparation, plan, and knowledge. That's the one he's going off of. That's the one the judge is looking at. That's not the one that Creighton is arguing. Creighton is honestly arguing just that he's trying to prove character trait, action, and conformity therewith. He's not making the arguments for the exceptions. So preparation, plan, knowledge. And then the last one, part of a common scheme or plan. That one actually, I think, is pretty good on the case law for not being part of this, because in order to do that, you actually have to demonstrate that this was one entire transaction. And I don't think the state's put forward any evidence to demonstrate that the shooting of Alex in September was part of the same plan that existed in June. So you have intent, preparation, planning, and knowledge. Preparation, plan, and knowledge. And then that kicks you into the analysis of whether the probative value of what's being offered outweighs the prejudicial effect of the information being offered. I already made the comment. I think the judge is going to let it in. I would be arguing against it. That's where I go with a lot of these character calls. I don't like the character evidence. The character evidence, I see it too much in domestic cases and in family law cases. It comes in to try and prove any number of things. I argue this stuff all the time. It drives me crazy. I know that prosecutors and defense attorneys take very, very firm positions one way or the other. I'm not in either of those camps. This part makes me quite uncomfortable. The idea that September 6th or September 4th, a shooting on the side of the highway, that we're going to let that in. A shooting that he paid for, we're going to let that in to be considered as evidence of whether he actually did the thing in June. You guys are going to disagree with me. That's fine. I have no problem with that. And honestly, you guys as jurors, you guys are pretty good. I mean, Peter says it every night. You guys are a pretty good metric of how these arguments are playing one way or the other. I'm in the camp of give me facts of the actual murder. Other people are swayed by motive. I don't know that this should come in, but we're going to get supplemental briefing on it. So we're going to get supplemental briefing. And then first thing in the morning, we are going to hear the motions argued by these two attorneys. God help us all. Because it's true that I lose brain cells hearing argument in some of these cases, or in this case in particular. So my synopsis of today. Let me see if I can do this. At the end of the day, Creighton Waters is allowed to ask the questions of Marion relating to the fear that Alex might have had and what went to substantiate that fear and whether this incident had any relation to that. He's not allowed to ask about any marital problems. I think that was probably excluded. And he's allowed to ask, I think he's allowed to ask about pills. So those are the things he's allowed to go into. Now, when he gets back up and he does some more redirect, he dances very carefully, very, very, very carefully. Because what he doesn't want the defense to use what he just asks in their motion tomorrow. So he basically dodges all of these hard questions, doesn't really go into all the different things that are super prejudicial. He kind of dances around them and he lays the little suggestion and he keeps it tight. Because what he knows he's going to do is this was the window that he wanted. He wanted this window open so that he could try and argue this tomorrow. Because if we see Cousin Eddie, if you thought this trial was off the rails today, yesterday, Friday, whatever day it is, if Cousin Eddie takes a stand, we're in big trouble because this thing has no chance of being done in the next century. So we'll see. Creighton Waters was really smart today in the afternoon. After he got that favorable ruling, he went back up to the podium, and the questions he asked were very limited in scope. He was going, I'm not going anywhere near this. I want to preserve this for my argument tomorrow because I don't want to kick this door wide open. I don't want to just dance around this issue. So we'll see. We will see. This is going to be wild. So we'll see that tomorrow. Catching up on super chats, and we'll get out of here because I have been doing this for almost an hour and a half. We're going to keep this thing short. Melly, thank you very much. I think he's responsible in some way, but no one has shown me how. Getting closer, but so many questions. If I'm on the jury, I'm on the fence. I don't disagree. Kristen, M96, we are taught to hit the mics with paper in grade school. Sorry, it's a South Carolina thing. Alex Murdaugh's brothers talked to James in court. He's having a recap tonight. Interesting. I'll check that out. Della Sandor, thank you very much. I'm a recent juror in Virginia. State hasn't proven the case. Thank you for the input. Courtney Michelle, thank you. I appreciate your input. Do you think having the timeline witness tomorrow's witness last is a good strategy? Yes. You need to make it make sense before the defense takes the stand, before the defense starts their case in chief. I could see that going either way. Sarah Lee, what's the difference between speculation and an expert saying this may or might have happened? The expert gets to testify and give opinion. Lay witnesses are not allowed to give opinion. Lay witnesses being witnesses that are not qualified as experts. Experts give opinion based on their knowledge, training, and experience. They're allowed to kind of go with hypotheticals and tell you what might or might occur with that hypothetical. Rebecca, have you seen the timeline? Brandy Churchwell did. I have that pulled up. I'm going to take a look at it this evening. JR, thank you very much. Maggie getting within 3 feet leads me more to believe it was her husband. She wouldn't have been afraid of him if she didn't see what happened. It's possible. I don't know. I need to get there though. Erica Felicia Reese, thank you very much. Could AM have gone between the chest and waist area pointing upwards? Sorry, I haven't shot guns since I was a kid. Just curious. I don't know. Della Sandor, thank you very much. I'm red bar blocked for no reason. F you Nightbot. I'm sorry, Della. Like I said, I'm trying to work on it. 9-inch nails gal, 1994. Thank you very much. If I ever get caught doing anything illegal, obviously need to just make sure I have fraud charges and get this prosecution team home free. Athal, thank you very much. I don't trust the sister's testimony. I think she has been axe to grind. As you can tell, she thinks her husband killed her sister. Do you think by the end of the testimony, some of the jury would see her that way? I don't know. They didn't. She came across pretty well. Be kind. I'm not watching this trial daily, so I appreciate these streams. These questions drive me nuts. They do to me. Thal, thank you much. Why would you cross her? Simple, to try and take away the sympathy the jury feels. Notice what he says when he starts. This is hard for me too. It's risky. Tony, thank you very much. Peace offerings for the mods. My apologies. Awesome show. First time here. Thank you, Tony, for being here. I'm glad to have you. Natalie, why dismiss the jury instead of a sidebar? Is that normally? This courtroom is too small. Suzanne Smith, thank you. Rob, thanks for delving into the case, strategies and evidence, legal arguments, etc. Thanks for not aiming to sway us regarding our opinions. Thank you. Amy, thank you. Random, but you always sound like John Cusack to me. Okay. This compliment. Thank you, Amy. Lori, thank you very much. Janet, no pressure, depression, wanted to die. I'm sorry. Oh, that one. Griffin, was he a suspect for the murders? He was shot? I don't think so. He wasn't. Y'all give me 2 seconds. I have to answer a door. Thank you. Sorry. I just, I order food based on the idea that my streams can be done in an hour. And I love Uber Eats. They do great. But every now and then you get the ones that knock. Like, leave it right on. Leave it at the front door, please. If you don't mind, leave it at the front door. Because I'm live streaming. And I don't have a really cool 30-second video that I can go down and answer the door. So, sorry, guys. That's on me. Totally my fault. So, let's see. Where did we catch up? Jeanette, thank you very much. I think it would work for the defense's case. Alex wouldn't pull the trigger himself. He'd pay someone instead. First degree needs to pull the trigger equals mistrial. I've been conflicted on this theory. I really have. Because I'll tell you what. If you're the defense and you argue that they have proven that he paid someone to do it, but they haven't proven that he did it, you don't think the jury's going to come back with a guilty verdict? That's a lot of trust to place in a jury to make a purely legal finding. No, I don't think you can make that argument, because the jury's going to find guilt, and then you're on appeal. And as Andrew Brank always says, appeals are for losers. You're not winning an appeal on that. I mean, you could, but you're placing a lot of trust in the appellate court. And I don't really have too much trust for the appellate courts. Creative Chaos, thank you very much. Can the prosecution give Cousin Eddie immunity about his upcoming trial if he testifies about this trial? Cousin Eddie would be a very interesting character to give immunity to. And they're not going to do it before he testifies. Because, Cousin Eddie is facing prosecution for all the bad things as well, and has motivations. And Dick Harpootlian, towards the end of the day, says, I have been waiting to cross-examine Cousin Eddie. You know, he gives 5 different inconsistent statements within a 5-day period. He seems rather motivated, so we'll see. But no, I'm not. You give him immunity before his testimony, and you have all those questions about all of his prior crimes and why he got immunity. So, Lauren Ellie, thank you very much. If Alex Murdaugh hired Eddie to shoot but not kill him, would that go more to motive? Furthers vengeance, narrative, distracts from scandal, storm, pattern, and behavior. Insurance card only needed if you live. It's an interesting argument. You have to put Eddie on the stand. And Eddie on the stand, Eddie has testified that if he was intending to shoot him, or if he was intending to kill him, he wouldn't have missed. Then he testified to having missed. Then he said any number of different statements. So there's a lot to believe there. Joe Loy, if only dogs could talk. Yeah. Right now, I'm happy that Bubba got vindicated. Honestly, the Bubba versus Rooster Army dialogue was my favorite part of today. Probably the only favorite part of today. Wolf Rebel, thank you much. Suburban parked at 10:05. The kennels 911 call was 10:06:14. So 19 seconds to check pulses on both bodies isn't reasonable. Okay. That part right there. So 19 seconds to check the pulses on both bodies isn't reasonable. So he lied about being down there at 8:44. He lied about being down there and checking the body's pulse before making the phone calls. Put the gun in his hands. I'm not saying that it's not good evidence. It's good evidence. What you are saying is good evidence. Is it beyond a reasonable doubt evidence? The other thing the prosecution did with all these financials and all these other narratives is the prosecution has kind of opened the door to this argument, or this thought that I have, that other people have, of what if he didn't pull the trigger? What if it was somebody else? Or what if he was cooperating with somebody else? Or what if, the more suggestions about the financials and the craziness, and the more that you get away from the actual night and the events that took place that night, the more that you allow these alternate theories to come into play. It's the downside to being so close to a case and prosecuting the criminal case for so long. You start to think that everyone's going to see the exact same thing, from the motive, through the intention, through the planning, through all of it. It's difficult. If he didn't check the pulses and he lied about checking the pulses, okay. Even if he knew what was happening or happened, okay. The prosecution's burden is to put the gun in his hand. And he was the one that did the shooting. With the ballistics, with the timeline, with the absence of blood evidence, I am having a little trouble. Now, the timeline guy is going to help, hopefully. And we'll see what he says. Thank you, Wolf Rebel. Cosmo, thank you very much. Appreciate your take on this. Thank you so much for taking the time for us. Thank you, Cosmo. I very much appreciate it. Impromptu, like I said, but hey. Andrew, this feels like a 1930s South Carolina trial where proximity and prejudice equals guilt for unfavorable defendants. You cannot make rules based on the worst of us. because it's not long before the slope starts to become pretty slippery. You have to preserve these rights for the worst of us, and you have to preserve the right to a fair trial for the worst of us. And this trial has me fascinated right now. Thank you, Andrew. KP, Rob, thank you. I'm not following this trial closely. I appreciate your recaps and professional opinion. Thank you, KP. Katja, thank you very much. The Frankenfurter. Hey, Rob, what do you think about Jim being the one who called them and told them about Alex being fired for stealing money? Yeah, Jim Griffin was the one that called. Let me see if I've got, I pull it down, but those clips are going to be everywhere. I promise you that. Jim Griffin almost became a witness in this case because he was the one that called Marion to say that Alex was fired. And when that gets brought up, Jim says, but that's hearsay. And the entire courtroom chuckles because it was out of Jim's mouth. So I get the point that it's technical hearsay, but I mean, Jim, that's why you shouldn't be the one cross-examining. Like, that's why all of that was a bad idea. Every part there. Just walk away. Take your case to your case in chief. So Brentwood Chic, yellow tie would look good with that shirt. Thank you very much. Elizabeth Mullins, thank you. We'll be very intrigued by jury instruction at the end. Me too, to be honest. Mary Margaret Cole, do you see any potential legitimate appeal issues? The financial stuff, but it's been so intertwined in this trial. I don't know how closely an appellate court's going to look at it, but it is most surely going to be an issue they're going to argue on appeal if he gets convicted, 100%. And I don't know. The prosecutor really stepped into it with just all the financials, like almost double the time of all the other evidence. So I don't know if an appellate court's going to view it that way. But again, appeals are for losers. Thank you, Mary Margaret. Matthew Self, thank you very much. The dirty prosecution, right? Which is bad. There's been tactics by both lawyers involved in this case that I thought have been a little bit questionable. Dick Harpootlian leaving the photos right there in the scene of the jury, in the presence of the jury. That's shady. That's shady. Giving a 1-minute monologue before asking a question. That's shady. Lawyers do things that are shady. I don't like seeing it. I've made the comment before that there's an attorney I know around here. I will not name names or anything else that reminds me so very much of Dick Harpootlian and Creighton Waters that it's like secondhand trauma. Like just listening to them argue, going, "Oh God, I just remember that trial." Della Sandor, Dr. Cyril Wecht, Michael Baden, Henry Lee for the defense. Okay. Debbie W., according to Chase Hughes, innocent people will try to get help, find out who did this, and guilty people will suggest a wide net of suspects. Marion's convo with Alex is this to a T. I'm not disputing a lot of knowledge on his part. It's what you guys are like not. What the evidence to me has shown so far is that he was the sketchy kind of person that would have the capability of doing or orchestrating or knowing about something about to happen. The evidence has demonstrated to me that he lied about being down there. I'm not looking into the motivations of the lie. The evidence suggested that even after the murders, he continued to lie, whether that was motivated by a desire to keep people from looking into his own finances or by some other reason. I'm not going to make the connection to a motive for why he would say the things he did. I agree with Chase that he's a liar. I'm not sure we agree on what that lie means, if that makes any sense. I wonder if it does. I'm not sure. Thank you, Debbie. Sarah Lee, thank you much. Rob, we didn't discuss lawyers crawling the ground. We mentioned it briefly. Sorry, I have an actual list of questions. Sarah, you can send those to me separately. You can send them to me by email. I'll take a look. I'll try to over the evening. But thank you. Yeah, the lawyer crawling on the floor. I haven't seen that before. So while asking questions, the lawyer's crawling on the floor and asking questions. No, that doesn't happen. Della Sandor, I just emailed Poot to watch you, Nick, Kurt, Branca. Oh, Della, if he's an attorney mid-trial, he's not looking at his email. He doesn't have to watch. He's closer to this case. He's closer to this case than I could ever be. He knows what rulings can come in and what things can and cannot happen. So no, I would never presume to tell him what he can do with this case. Professor of Logic just asked the dogs what happened. I'll allow it. Fair. Terry Moore, eat, hydrate, and commentary. I try. Thank you, Terry. Type 1 bricks and pieces. Why did no one ask the time of deaths? I don't know. I don't know. I felt that would be at least favorable to the defense if they were going to ask the question. Why did no one ask the question? I'm so confused. FYI, to the people asking, yes, I've texted Chase whenever he is free. I will hopefully connect with him and ask him those very same questions. Yeah. Professor of Logic, seance with the spirits of Paul and Maggie for the prosecution. I'll allow it. I don't know if I'm going that far, but you never know. Claude, Simeon, Rob, I assume it's coincidence, but thanks for making tough nights like Singles Awareness Day bearable. You're an inspiration, star. Thank you, Claude Simeon. It's, I like being here. It's kind of fun. I enjoy just talking through my thoughts. That's what it is. I'm talking through my thoughts with you guys and parsing things through in my brain, kind of in retrospective how the trial proceeded. But thank you. New Zealand Butterfly Girl, Heather, thank you very much. Prosecution hasn't proven their case yet, but if Alex wasn't involved, why so many lies? I don't know. It doesn't look good. That's true. I can't make sense of it if he's innocent. I don't know. I have questions. I hate to do that. Yes, that's Emily. That's what she says all the time. But there's just no way of going about saying that other than there are still gaping holes in some of this story. I know that there's been a lot of investigative reporting on a lot of this stuff. Tons of investigative reporting. And I know that there are people that are just very, very interested in this case from start to finish. I have not been investigating this on the ground the whole time. I have not, and I do not know those stories left, right, and center. I don't add value there. I don't add value to people who do the investigative journalism. Where I feel that I can add some context is in the legal analysis of what is or is not admitted at trial and the consequence of admitting these things and how they stack up towards a burden that is imposed upon the state based on the charges they filed in trying to hold a person accountable for acts they allege occurred. That is what I'm trying to add. I'm not trying to steal anyone's thunder or say anything that happened or didn't happen. I'm just viewing the evidence and trying to apply it to the legal standard. That is it. And trying to give you guys the tools that you need to address the questions you have with a little bit of context from the legal side. That's the important part for me. Leanne, thank you very much. Here's my crazy motive theory. That detective nickname, what if Paul was basically extorting AM by always threatening to expose his addiction for money? Boat case looming. That's a lot of liability. It is. I think that based on what you have seen, as far as the testimony about their relationship, I think a jury would have a trouble reaching that based on the information in front of them. That's just my thought. Because even Marion was talking about the relationship that was between Paul and Dad. I just think a jury would have trouble buying that. A jury might. Professor of Logic, in defense of my previous super chat, the defense shouldn't have opened the door by bringing up Paul and Maggie. Professor of Logic with the sarcasm. I love it. How far are we going to go in this trial? We've got finances of all kinds in. Can we get back to the actual murders? I would appreciate some of that evidence. Marnie, thank you very much. Alex is part of the FBI drug trafficking investigation. Maybe they were killed in front of him by cartel. He has to cover them to protect the family. I don't know. I don't know if that works or doesn't. I could see it seems pretty far afield. It seems like a little bit of speculation, but I mean, possible. Bop it. Thank you. The Roosters started. We puppies stick together. Bop it. The pupper. What are you? Look at the Chocolate Lab. I think Chocolate Lab. Yeah. I don't know. But the rooster passed away and died in the battlefield. So the rooster is no more. Dogs prevailed at the end of the day. So, okay, wrap this thing up. Melissa Harden, thank you very much, was a suspect in homicides and needed a distraction to throw SLED off the scene by playing victim. Suicide was just another lie. It's possible. That is. 9-Inch Nails Gal, we need Dr. Doolittle to come solve this. Talk to the animals. Thank you, 9-Inch Nails Gal. Niner, thank you very much. Important. How did the wings go over at Super Bowl? They were great. I didn't actually surprise people with them. We were able to do a lot of the wings without surprise. 2 of my friends were very unhappy at the wings. They thought that it would not be as spicy as it was, despite my warnings to the contrary. They thought they were totally going to win and be able to take those wings without a look on their face. They did not enjoy the moment, but it was fun. Secret Squirrel sent you gifted names via DM. Thank you, Secret Squirrel. I'll pull those up in just a moment. We'll get those before we get out of here. Thank you very much. Della Sandor, thank you very much. Poots boys are watching emails. You're all so smart. Interesting. 9-Inch Nails Gal, there was murder. The detective suspected the artist first because he was sketchy. Missing truffle hat. Yeah, that's a good one. I like that a lot. So, let me make sure I've got the last one. Baby Gator, thank you very much. Right now, I'm at not guilty, even though I don't think he is 100% innocent. I'll tell you right now, I am most certainly not at Alex Murdaugh is innocent of just human badness and all the terrible things. I'm convinced beyond a reasonable doubt that he's guilty of the financial crimes. We didn't have to get to the financial crimes trial because all the evidence is here. So, yeah, he's guilty of all those. I still I'm not to that threshold, the beyond a reasonable doubt threshold with regard to these 2 murders. And I'm not saying the prosecution can't get me there. And I'm also saying the defense can't get me there accidentally by slipping up in their own case in chief. So that's what I'm saying. The defense putting on a case, just like the defense cross-examining Marion today, it's a double-edged sword. Because that can lead to people questioning a lot of things. EP, thank you very much. What if Alex did not want to live without Maggie and Paul and made such a mess of his life that he wanted to die, but wanted his other side to be taken care of? So he's staging the car shooting. That's a possibility. Nicholas, every bad witness from the prosecutor has been for the sole subject of making defense opening doors. And with this judge, it became easier. That's an interesting observation. I think that Creighton Waters on the direct was very, very well, he really didn't go into too much. I think he might have known that the door might have been opened. And I think the whole open-ended question led by motives and killings in the same sentence was might have suggested something. So gifted memberships. Thank you very much to Brentwood Chic for gifted memberships. Jan E. Wallace, Crystal Taylor. Thank you. Ali Foley, 82. Thank you. Cindy T, Brentwood Chic again, and Sandra Ramirez. Thank you guys for the gifted memberships. I wish StreamYard could show me those. Barney Cat with another 10 gifted memberships. Thank you all so very much. I've got these last 2, and then I'm getting out of here. Bop it. Yep, I'm a chocolate lab. My mom's a retired canine handler. She has thoughts. I imagine she probably does. Rebecca, James from Court going live after you. Well, we shall clear the way. Thank you guys for joining for this midweek stream, doing a little breakdown from today's evidence and trial. We'll see what happens. I will be likely watching tomorrow. I don't have trial this week, which makes things nice, so I can actually put this on in the background while I'm working. So I might have thoughts. Thanks for being here, guys. I really do appreciate it. It's awesome. Great getting catch up with all of you. I will see you next time.